This video is going to be addressing removal jurisdiction. I have up on the screen two different examples of removal jurisdiction, but let's back up and put this into context. This is material on the federal courts, and at page 12 of the textual outline, I have a paragraph about removal jurisdiction, and there I say that a case that originates in state court can be removed to federal court if there is an independent ground for federal subject matter jurisdiction. And I have two examples of how that could happen on the screenshots that we'll be looking at. And again, what we're looking at is that a case has been brought by the plaintiff in state court. And we're going to see two different instances where the defendant had the ability to remove the case. And as you guys would say, literally have the case moved from state court to federal court. Obviously, when this happens, the attorney for the defendant wants to have the case heard in federal court rather than state court, and perhaps I can shed a little bit of light on why that might be the case as I'm going through these examples. In both of these examples, I was involved in the case, and so I have some sense of how this works. So, and again, I get interrupted sometimes because I'm working in my law office and I occasionally have to deal with income. But I have removal jurisdiction example number one up on the screen. And in this case, the plaintiff was a New York resident, and it sued the defendant, which was a Texas corporation, in New York State Supreme Court, and the venue that was selected was Niagara County. More on venue in a later video or posting. In any event, the claim was based on breach of contract. In other words, the plaintiff was alleging that the plaintiff and the defendant had entered into a contract and that the defendant failed to perform, and the plaintiff was claiming that it, because it was a New York partnership, it was entitled to approximately $300,000. Now, what we want to maybe spend a minute on is the defendant's position, practically speaking. And what the defendant knew, of course, was that plaintiff was on the home field, so to speak, and without at all suggesting that there was any corruption involved, though I think sometimes there is, but without believing that there was any corruption involved, the fact of the matter is the defendant knew that the plaintiff was in its backyard, because the plaintiff headquarters was in Niagara Falls, and that New York State Supreme Court judges are elected, and the defendant was concerned that perhaps the plaintiff had a cozy relationship with the judge, and to the extent that the judge had discretion in the case, perhaps that would operate against the defendant. Plus, the defendant, I believe, knowing the defendant's attorney, believed that the defendant's position could be comfortably litigated in federal court, and unlike state court judges in New York, federal court judges, as we learned most recently with U.S. Supreme Court vacancies, federal court judges are appointed for literally good behavior, but that means really for life or till they retire. So there seems to be less of a chance for political pressures. So the defendant had a motivation to get the case out of the New York State court and into the federal court. question becomes, could the defendant do that? And the rule is I have in page 12 of the outline, removal jurisdiction. If the case is in state court, it can be removed if there's an independent ground for federal subject matter jurisdiction. And if it's a diversity case, there's an extra requirement, and that is that the defendant has to be out of state. So in this case, this example, there was a basis for a diversity jurisdiction because the parties were from different states, namely New York and Texas, and the claim was in excess of $75,000. So we have diversity, and the rule for removal, if there is diversity, the defendant had been sued in the court of another state. And so what happened in this case is the defendant removed the case from state court to federal court. And we're not going to get involved in the process, but it's really a simple one. The defendant just fills out paperwork, or the lawyer does, files it in the state court, files it in the federal court, and the case goes from the state court to the federal court. In this case, there wasn't a basis, there was not a basis to object, but if the plaintiff objects to it, the plaintiff must lodge the objection in federal court where the case has been removed. So that's one example of removal jurisdiction. I'm going to go down to the second example. And in this case, again, the case was sued in New York State Supreme Court, and the venue selected, there's 62 counties out there, Niagara County, and I was involved in this case as well from the defense perspective. The first case I was involved in the perspective or position of the plaintiff. Well, the plaintiff in example 2 was a New York school teacher for a particular school district. And the school district sought to terminate the plaintiff's employment, which is a procedure under New York law. But the plaintiff claimed that the school district's decision to remove the plaintiff from employment was really in retaliation for the plaintiff making public statements critical of the school district, and it really had nothing to do with what the defendant had stated in the removal procedure in New York State, which is an administrative proceeding, which was that the plaintiff had committed misconduct as a teacher. So again, the plaintiff is saying, nah, that's really pretextual. I didn't commit any misconduct, and the reason they're out to get me is because I had exercised my constitutionally protected First Amendment right. Now, under federal law, there's a claim, sometimes known as the 1983 claim, and it's found in Volume 42 of the United States Code. Congress passed it years and years ago. And basically that law provides for a claim against a state governmental union or state official if that governmental unit or state official has violated someone's constitutional rights. So in this case, the plaintiff in New York was saying the school district terminated me because I was exercising my First Amendment rights. That's prohibited under 42 U.S.C. 1983, so that was the basis for the lawsuit. Now, in this case, the claim was brought under federal law, so we have federal question jurisdiction. And where we have federal question jurisdiction, and it doesn't matter then about the residence of the residency of the parties, because it's a federal question case, we're not worrying about diversity. And since there was a basis for federal question jurisdiction, namely the claim was brought under the federal law, 42 U.S.C. 1983, the defendant could remove the case to federal court, which the defendant did. And since that was my decision, I can tell you what motivated me was I believed in this particular case that the federal courts were going to be more experienced experienced in dealing with this type of claim, and that, quite frankly, because I thought it was a weak claim, it would be easier to get the claim dismissed in federal court than perhaps state court. And so that's what happened. And, I don't have a crystal ball, but as it turned out, the claim eventually was dismissed in federal court. There's a final point I want to make about example 2, and if you were to turn to your, when you have a chance, to your textual outline, page 11, there's a footnote. And what the footnote says is that in most federal question jurisdiction cases, and this is precisely an example of one, the one that's up on the screen now, in most federal question jurisdiction cases, with a few limited exceptions, that case can be brought not only in federal court but in state court. And that's what the plaintiff did. So, in other words, the plaintiff wasn't prohibited in the first instance from bringing the case in state court, but having done so, the defendant had the choice of bringing the case, or better said, removing the case to federal court, which happened here. And the reason I like to spend a little bit of time with removal, and I hope this is illustrated by these examples, if you're working as a paralegal for a law firm that does any kind of litigation, these two examples are not unusual. They're going to happen in the regular course of business, so I didn't want your mind to get blown when you ran into a situation where a case in state court was removed to federal court. Okay, that's it.